So good afternoon, ladies and gentlemen. You're all very welcome to this afternoon's webinar. The webinar is a joint collaborative approach between Arbitration Ireland and our colleagues and friends at BlackRock Expert Services. My name is Gerard Monaghan. I'm the moderator for this afternoon's event. We have a very interesting topic for you this evening on the impact of technology on construction disputes. And I guess the reality is it's really, we're going to look at construction disputes and construction delivery, and the two things really go hand in hand in many senses. I'm a chartered engineer and an arbitrator, and those of us that have been involved in construction project delivery I've been involved in maybe publicly funded infrastructure projects for the last 25-30 years, will have seen a huge advances and proliferation of digital technologies in terms of how we deliver construction projects for the last 5 or 6 years. Be it BIM 360, be it drone technology, be it data analytics or otherwise. And really they bring great efficiency, in my experience, to the delivery of projects. It's really about real-time management, real-time control of program, of cost, of resources, of quality of work. You can really access the data from your laptop, from your desktop, wherever you are. And the world of construction delivery has changed for many of us, and for the better, to my mind. By extension, then, you know, the big data that we gather from the delivery stage naturally flows towards the data that parties rely on at dispute resolution stage, be it adjudication or arbitration. They rely on the data that oftentimes is shared between the parties. So really, it's important for all of us, I think, that are involved in construction projects and delivery and dispute resolution, be we engineers or architects, or project managers, lawyers, arbitrators or otherwise, to understand the technology, the benefits of it, the limitations of it, and try and get a sense of where it's going in the marketplace. We've four excellent speakers for you tonight, I should say, and I'll introduce them to you in a moment. There's a Q&A function, you should see it on the screen. So I estimate that the speakers will take maybe 45-50 minutes, and we have a Q&A session at the end, which I'll moderate. So if you have any questions, please feel free to include them. I'll introduce the speakers to you now, and then I'll hand the floor over to each individual speaker. So the first speaker this evening will be Declan Fitzgerald from BlackRock Expert Services. Declan is a chartered engineer with approximately 14 years delivery experience. He specializes in providing clients with strategic advice and delivery capability, particularly in the areas of program management and program controls. Declan will be followed then by Owen O'Murricu from BlackRock Expert Services. Owen is a chartered civil engineer with 12 years delivery experience. He has a background in construction technology and specializes in providing targeted advisory services to complex capital projects and delivery organization, particularly in the areas of program, project efficiency and program management. Owen then will be followed by Siobhan Foster. Siobhan is a chartered IT professional with over 7 years experience in technical analysis. Siobhan specializes in the forensic analysis of historic project material, focusing on the measurement of program and project performance within a variety of methodologies such as Waterfall, Agile and Prince2. So that kind of historical viewpoint will be very important in terms of dispute resolution, and Siobhan will talk about that. And last but not least, then, my Arbitration Ireland Committee member, Rory Curran, SC. Rory is a partner and head of construction, infrastructure and utilities and co-head of energy at Mason, Hayes and Curran Solicitors based here in Dublin. Rory was appointed as senior counsel by the Irish government in 2020, and Rory has the distinction of being in the first group of solicitors to receive this distinction. So well done, Rory, on that. Very briefly then, the agenda, Declan will kick off with a brief overview of the changing landscape of technology and construction. Owen will then talk about some of the technological developments we are seeing now and may see in the future in the engineering and construction sectors. Siobhan will discuss what we see as the core technology and data challenges facing the industry, particularly in the context of dispute resolution. And last but very much not least, Rory will wrap up the presentation with a view from a legal perspective view in effect. So with that, I'll hand across to Declan to kick off. So Declan.
Super. Thanks for that, Ger. My name is Declan Fitzgerald, and in this section, I'm going to talk about the context around the increasing role of technology in construction and the key points in the sector's journey to this point. So if you go on to the next slide, Sarah, let's talk about let's start with the problem statement. So construction productivity has stagnated versus other industries. So taking the UK as an example, while overall productivity has risen by almost 30% since 1994, construction productivity is up by only about 7% in that same period. So it's an industry that's been plagued by low predictability in outcomes, poor communication and reporting, a cultural lack of collaboration, which is often underpinned by adversarial commercial and delivery approaches, and resistance to disruption and change. Now, another factor contributing to this has been the historically slow uptake in embracing technology. So according to research by Gartner, the construction sector ranks above only agriculture in terms of digitization in the top 22 economic sectors as of 2015. However, there is room for optimism in the sense that investment in technology and construction has doubled over the course of the decade leading up to 2018. Industry research estimates that by embracing technology in both the delivery environment and in the supporting back office functions, savings of about 20% are achievable in delivery organizations. And this doesn't account for things like opportunities that may be realized through delivering projects faster and to a higher degree of predictability, which would unlock capital for opportunities elsewhere. Now, being an early adopter is increasingly being seen in the industry as a competitive advantage. However, as with all changes, there have been teething problems that the industry is grappling with. These include things like data ownership and collaboration, structuring of data, and integrating multiple discrete systems. Owen is going to talk about some of these challenges and more in a later section. Notwithstanding these challenges, though, the pace of change has continued to gain momentum and increase over the last number of years. So compared to the noughties, for instance, the pace of change has never been as quick as it is now, but looking forward, it's unlikely to ever be as slow as it is again. Now, and this is not just our opinion. So if you'll go on to the next slide, Sarah. So this is not just our opinion. The industry has published multiple reviews on papers that touches on exactly this point. So an example of one of these is in 2016, the Farmer Review was published. This review basically identified that technology adoption was a key enabler for improving the construction sector's productivity. It also identified that one of the main barriers towards improvement were issues around low industry margins, which drive a culture of poor collaboration and fragmented leadership. Now, collaboration and strong leadership are both key enablers in any change initiative. So it recommended that governments and public bodies take a more proactive role around driving changes in the industry. And we're starting to see some of this through larger public sector initiatives and procurement processes, which have been driving change into their subsequent contracting arrangements, both with prime contractors and their wider supply chain. So let's take an example of one of those things. It's now, relatively common for large-scale public contracts to require tenderers to describe new and innovative technologies and approaches to delivering particular projects as part of the tendering phase. Now, if a contractor is required to demonstrate innovation, and that innovation is the difference between winning or losing work, then they're much more likely to focus on this compared to previously. Now, the key takeaway on this slide is very much around as the construction industry changes their approach to delivering projects with technology as a key enabler, it's going to have an impact on the nature of disputes involving those same projects. Now, it's too early yet to say what the change will be, but it's likely to impact on pretty much everyone in this audience. Now, it is safe to say, though, that as the volume of data involved in these projects will increase dramatically, the level of subjectivity should decrease correspondingly, and we'll start to touch on what we mean by that later. So on the next slide, how has the industry been changing? Well, for a start, delivery organizations are now gathering data of projects that they've completed on a much wider scale over the last decade. Now, this data is often being used to do things like benchmark cost submissions for new projects. The benefits from a contractor perspective on this is they're likely to be able to forecast to a much higher degree of predictability and much more efficiently through the intelligent use of data that they already own. Now, on the other side, public projects are also likely to require benchmarking exercises to be undertaken at key decision points. And we're starting to see this being mandated on some larger public projects through recommendations from the UK's Infrastructure and Projects Authority. And we expect to see that broadly more internationally, adopted more internationally as well. Now, traditionally, this data set was driven by relatively simple things like Excel sheets for cost and risk plans, simple Gantt charts for scheduled programs, and progress reports that were often based on narrative and compiled in things like MS Word and circulated amongst the team. Now, that's what technology meant as recently as 15 or 20 years ago on a typical construction project. Now, as a demonstration of how far non-traditional forms of technology and data are currently driving innovation, if you were to ask someone on a typical large-scale construction project now what technology means for them, you're likely to get answers that involve things like Ger mentioned. You're going to get answers around drones and LiDAR surveys, the adoption of wearable tech, or things like the use of GPS sensors on heavy equipment to monitor locations and movement to track the most effective use of those assets to increase efficiency. Now, embracing technology is still very much at the forefront in thinking on the delivery phase of capital projects. And that's what we're going to focus on in the remainder of this presentation, i.e. the delivery phase. But technology is also significantly impacting the end user and asset managers of those same projects. Now, each of those use cases will be an interesting topic in their own right and will probably require a similar length of time to cover. For example, technology requirements from an end user perspective is driving significant additional complexity in the delivery of projects. 15 years ago, for instance, commissioning a building wasn't much more difficult than just making sure things like telephone lines, power lines, and your fire systems worked. Now, with the advent of IoT, that has changed. I recently worked on a dispute where this actually drove the critical path and was a key part of underpinning on the overall delay on a project. And simply put, the fire alarms in this particular project required that the data systems to the building cut all media in the event that an alarm was triggered, which it didn't. This resulted in the building not being certified as safe or actually fit for use until that particular issue was resolved and subsequently became one of the key points in the opinion. Now, examples like this demonstrate that technology is very much changing the landscape of construction and construction disputes now, and it's likely to also continue to impact those in the future. And it is, on the next slide, Sarah, if you can. So it's anticipated that the impact of technology in the sector is going to drive things like greater reliability in the key project delivery metrics of scope, cost, time, and quality. And that's going to be underpinned by better and real-time project data. Now, intuitively, one could jump to the conclusion that this will significantly reduce the volume of disputes in future. However, the jury is still very much out on that one. So as projects become more and more complex, some disputes are just simply going to be unavoidable. But from an expert witness point of view, the journey is very much likely to lead us to a point where our role is going to be more about things like who can most effectively tell the story using the power of big data and technology as their evidence base. And with that, I'm going to hand over to Owen, who's going to discuss the role of technology in project delivery now. Owen?
Thanks, Declan. So as I said, my name is Owen O'Murchu, and I'm also an Associate Director in the BlackRock Delay and Project Advisory team. So Declan has provided us with a good overview of the challenges the wider engineering and construction, or E&C sector, has faced historically. Now, our aim for this section of the presentation is to further examine the benefits of technology in the delivery of projects and consider some of the potential implications and impacts for disputes. So my part of the presentation will focus on three areas. I will provide a brief overview of two examples of forward-thinking technology adoption on E&C projects. I will then take you through the challenges of tech adoption in construction from a real example I was involved in recently. And most importantly for this audience, I will put it all in the context of dispute and leave you with a few things to consider. But before we progress, it's worth referring to what is, I'm sure, a quote you've all seen a number of times from the late Max Abramson on the importance of records. Now, all new technology tools in the E&C sector recognize the core message in that quote, with the most successful ones improving the records and decision-making abilities of projects. Just something to keep in mind as we progress through the rest of this presentation. Now, the first technology advancement I want to touch upon is the concept of the digital twin. Now, the digital twin journey is a great example of how the industry is embracing technology advancements in a step-by-step manner, leading to wider delivery and performance benefits. But what is a digital twin? Well, simply put, it is the evolution of the traditional engineering BIM or 3D model. In plain English, this just means creating a highly complex virtual model that is an exact counterpart or twin of a physical thing. That thing could be a car, a building, a bridge, you get the idea. Now, many of you are probably thinking, how is this different from a BIM model? Well, in short, it is far more complex. Let me put that into context from a traditional building perspective. Now, a digital twin layers a typical 3D model with other relevant sources of information, such as delivery cost, project risk, live progress data, material information, etc., creating a rich source of information in a single location, available to all parties on the project. Now, this shared information source is often called a common data environment, but we'll circle back to that terminology later on. Now, new tech advancements are really starting to unlock the potential of the digital twin. For example, on the construction project, steel beams can be RFID scanned via a QR code or a fob as they are installed, which will update the as-built records in the digital twin in real time. The project site can also use 3D scanners or drone surveys to capture plan versus actual dynamic real-time progress on the project. So in short, anyone looking at the digital twin now can see crucial information about how the physical thing is doing out there in the real world. So this all sounds very interesting, but why do I care? Well, in theory, the digital twin will connect all disparate systems and parties on a project, enabling reliable records at a specific point in time to inform key project decisions. Again, for example, photo imagery surveys can automatically detect if the as-built progress on site is per the plan. The digital twin will detect delays or issues and bring them to the attention of the decision maker, who can proactively address them before they become a major issue, thus mitigating things like likely delay events, for example. In essence, it promotes decision making based on data and will help inform why actions were taken at a later date if required, something which has obvious implications for disputes. Now, this ability to inform decision making in real time is in the long-term asset management of assets, which is really driving the adoption of the digital twin technology, particularly as we move towards a world of smart buildings and smart assets. Now, through sensors, assets or buildings will constantly inform the digital twin of how it's performing and where potential issues could arise. Engineers can then proactively address these issues before they become critical and assess the impact either in person or remotely, again, via the digital twin. Now, I really like to use bridges because I think they're a great example. And I always like to make reference to the Christmas closure of the iconic Fort Bridge in Scotland, or even the Broad Meadow Viaduct collapse in North Dublin a number of years ago, as an example of incidents of unforeseen events. Now, had both bridges been retroactively connected in with sensors to monitor structural defects, it's possible that significant issues and costs could have been avoided and detected potentially through a digital twin model. Drones are another tool that are often playing an ever-increasing role in the long-term management of assets. And I know the likes of linear assets such as railway asset owners are using them to inspect their railway tracks, and will be another source of live information on the long-term management of assets as this technology progresses. So this is really an exciting space in the industry with a lot of private and industry investment. But what does all of this mean for disputes? Well, the industry is slowly beginning to adapt elements of best practice in this space. For example, the UK government has introduced 2016 BIM Level 2 protocols, a small step in the direction of a digital twin. Like Declan said, I'm sure other European nations are going to follow suit in the not too distant future. But however, as we move to other ways of working that rely more heavily on shared information, we need to consider such things like data and IP. Who will own the data on these shared project models, and will information be compatible across contracts? How will we manage this increased volume of data, and do we even have the right skill sets in our organizations to do this? And where will the liabilities lie for decisions that are made when information is based on integrated models? Now, while the benefits I've outlined for the adoption of shared information is clear, we can already see that the introduction of a more integrated project environment may blur the lines on where liabilities, risks, and responsibilities lie on projects. Something to consider going forward. So as we become more integrated, as I said, on projects and seek to harness the benefits of things like the digital twin, it is clear that we will need the ability to manage, interpret, and consider ever-growing volumes of data and information. Now, as the volume of this information grows, so should our capabilities to derive accurate insights from it. Now, leveraging the power of things like data analytics, machine learning, and ultimately artificial intelligence will offer huge opportunities to the wider engineering and construction sector in the management of large volumes of continuous data. So again, let me put this into context by a simple example. So we touched upon the sensor data and RFID tagging of steel beams on a construction site. So if progress is delayed, using analytics, we can seek to optimize performance by comparing live as-built records with things like crane utilization, delivery records, and identify the root cause issue impacting performance and what tasks could potentially need to be prioritized. So in short, analytics can help us identify trends in information and rapidly distill data into simple KPIs and performance observations. But increasingly, the opportunity to streamline operations will mean the introduction of more powerful tools, such as machine learning and artificial intelligence. Now, in the immediate future, it is more likely we're going to see things like machine learning, which learns from past project data to predict future performance, to make informed project decisions that will increase project control and eliminate bias. So again, machine learning tools can link live weather data, for example, with traffic patterns automatically to plan and optimize project schedules based on real-time information, or indeed monitor real-time curing of concrete via sensors to speed up and turn around priority tasks on site in real time. Again, the opportunities are limitless. We just need to seek them. But in the longer term, as the data sources and technology integration becomes more advanced, we will likely see steps into artificial intelligence, enabling machines or computers to simulate human behavior and rapidly address complex issues. So AI could support engineering teams to sign off complex design details on projects or even actively manage contracts of a wider supply chain. The key difference here being that AI can make independent decisions, where machine learning is based on past data. So benefits. So in theory, the adoption of AI and ML will lead to more efficient and reliable project performance, including delivery efficiencies, better reporting, issue identification, risk mitigation, and greater certainty in schedule planning and control of costs. So brilliant. No more need for disputes. Well, not really. I think this brings a whole new set of issues and questions to consider. So for example, what if there's an error in the algorithm that is informing key project decisions? How reliable is the project data? Is it of the same quality and consistency across the project? Where do the responsibilities of AI and human intervention meet? And other things to consider are, will we blindly accept general software T's and C's as we do now? Or will project-specific ones need to be identified? And how will the industry overcome fundamental issues like data structuring, such as naming conventions and data quality across the wider project supply chain? Now, these are just some of the initial dispute issues that spring to mind. Advances in technology are important, but it's also important we don't lose sight of the challenges involved and how this may impact us and the dispute sector in general. Now, what I've just talked to are some very forward-leaning ideals in the construction sector, and the industry is very much on a journey to that level of technology adoption. But to put all of these opportunities and challenges into context, I want to take you through a live example from a major construction project I was involved in the recent past. Now, this example talks through the complexities and issues that can be found when integrating various different project data sources to drive delivery efficiencies, a key goal in a lot of projects. Now, my role on this project was to lead a team of specialists brought in to identify efficiency opportunities on a multi-million-pound high-rise development in a city centre location. Now, the project was facing the typical construction issues, increasing costs, tight schedules, limited space, and a complex series of delivery logistics. So as such, we were given access to all schedule, delivery, crane, utilization, key emails, and people data for the entire project. Now, the project was capturing a lot of really interesting data, but had not integrated them in any way. In essence, we were trying to reverse engineer a common data environment and identify opportunities for delivery efficiencies. But immediately, we ran into a number of fundamental issues. So when we tried to integrate the independent data sets, it was clear that this would be a challenge. They were in different formats, different naming conventions, and data structures and information could not be compared easily across the sources. Again, a simple example of this, the schedule had called the main contractor ABC Limited, but the crane log referred to them as ABC. Now, this may seem like a minor difference, but one that a simple data algorithm and machine learning toolkits may struggle to reconcile quite rapidly. A second issue we encountered was we found that quality and data and information varied dramatically across the project, both in volume and in terms of reporting cycles. It also varied across the maturity of the project and by data owners, which made it even more difficult to establish this proxy common data environment. So again, we found that the delivery records were scarce on detail in places with no standardization due to the use of free text. The regular of RFID tagging or tracking of people on site had also not been aligned to the schedule of works on a particular day. So we found that steel would arrive on site on days when steel fixtures typically did not work. So there's that lack of integration across the project to really use that data as an asset. And lastly, the internal capabilities of the client in managing and storing and assessing data were limited. While they had taken initial steps, there was still a long way to go to utilizing all of this data as an asset in its own right. So to put that into context, it took a team of approximately 10 data scientists over 6 weeks to categorize, review, and cleanse all of the data and to drive insights from it. The contractor had one data scientist in place across a number of projects, so this was an impossible task for any one individual. Now, drawing on a team of data scientists, as I said, my team was able to identify a lot of interesting insights. Key project decisions were being bottlenecked by 1 or 2 individuals due to limited capacity to review emails in time, a real case for machine learning or AI decision making. From the RFID gate fobs, we're able to track people movement and link the level of inexperienced resources on site to increased health and safety events that had occurred. And in crane utilization, which was perceived to be near 100%, was actually in the low 40s due to missed bookings, late deliveries, and poor use of its available time. Now, all of these data and technology issues were fundamental in their nature and will be commonplace across many projects and programs. But why am I telling you all of this, and what does this mean for disputes? Well, as data-rich disputes become more and more prevalent, with the nature and volume of data ever increasing, similar challenges will be faced by dispute legal and expert teams. How can we ensure that we can see the wood through the trees and not get buried in the volume of information we're receiving? How can the dispute sector adapt to this to ensure that they can manage and mitigate potential data challenges? So putting all of this into a disputes context is important. So in short, as changes happen in the delivery of construction projects, the dispute sector needs to adapt and evolve with these changes. Now, the issues that I've described in the dispute sector and the issues that they will encounter going forward can be summarized in 3 groups. Firstly, around data ownership, such as the IP of organizations working within a shared data environment. As data becomes more aligned across projects, how will that impact disputes? And will the nature of disputes evolve into information ownership or data origin issues? Another thing to consider is data structure. Will future disputes be about how information was maintained? Will simple things like naming conventions play a bigger role in project outcomes? And could we see disputes on specific data agreements in the future? And even simple things or even more complex things, for example, like systems integration. The key challenge with new tech is its integration, and the assumption that it will work smoothly is often an overriding one. But we all know that is not the case. How will future disputes manage tech, and will it be about the technology deployed and not about the project itself. So how will common data environments expose parties in disputes, and will they introduce measures to minimize information they share to the detriment of projects? So in close, there are issues that will need to be addressed and will appear as challenges as technology adoption grows in construction projects. One thing is for sure, future disputes will be underpinned by the need for technology and data capabilities, as the graphic on this slide shows. My example earlier touched upon the size of the team needed to assess relatively simple project information across a common data environment, underlying the importance of the right capabilities. Is the sector ready to meet the challenges that lie ahead? Will law firms and expert firms be partnering with digital startups and using data scientists as opposed to more traditional ways of working? For me, the key question is about how we can learn from parallel industries, such as the manufacturing sector, for example, that have already taken advances in this space. Whatever the case, the volume of data on projects is growing and will continue to do so. So with that, I will now pass you over to Siobhan, who will take you through some more of the practicalities and challenges these issues bring to live disputes.
Thank you, Owen. So I'm going to look at disputes and litigation where technology hasn't enabled project success. I'll be covering how technology is currently supporting and impacting disputes in terms of legal tech and required skills, and types of tech-based disputes, and then the impact of E&C technology advancements on future disputes. So starting with how technology is supporting disputes presently, you'll see on the slide that at the heart of the graphic is the data in disputes and the presentation and preservation of it. Some of you will already have heard of existing e-disclosure review tools available at the moment, such as Relativity, iConnect, etc. These platforms presently support large data sets of varying file formats to assist the review of disclosure within disputes. Over the last few years, these document management platforms have evolved greatly. So current capabilities, as I'm sure some of you will know, include technology assisted review, or TAR, which utilises machine learning to electronically classify documents based upon input from reviewers. And TAR has enabled the reduction of manpower in legal review by performing those tasks of a human, such as identifying what documents are relevant or irrelevant within the data set. In some e-disclosure platforms, AI integration is becoming more refined, so performing the formation of case strategies and document assembly. Because of those capabilities, however, the e-disclosure platforms themselves have gotten really complex systems to use, and new features are coming out all the time to manage the increase in data file formats. When it comes to e-disclosure, electronically stored information can be held in numerous formats across multiple locations and jurisdictions. So if we think of emerging technologies being more readily adopted in E&C projects, the Internet of Things, smart cutting tools, etc., then it's easy to understand how e-disclosure platforms are going to require even more technical specialists to manage the data involved, and that's just in consideration of getting to the dispute stage of legal review. There is a difference between collating real-time project data such as drone imagery, wearable tech, etc., for making live project decisions than there is for collecting data required for expert analysis in a dispute. In dispute analysis, collection of sound evidentiary material is imperative, and there's many stages to handling electronically stored information, but foremost, it needs to be acquired forensically in order to maintain the accuracy of the data. So as the slide shows, already we've seen a wide array of contact points and skills required in relation to disputes data at present. In short, if we consider moving forward that more traditional paper-heavy industries are adopting technology, we are likely to see the required skill sets for data handling increase. Since we expect that construction will at some stage inevitably become even more adoptive of technological advancement, bearing the previous slide in mind, we ask, do law professionals need to increase their tech knowledge, or do we expect that cases will incur more costs for technical expertise, perhaps both? As Owen stepped through previously, an abundance of project data could be a really positive thing. Having a wealth of information would surely enable dispute lawyers to make a better case, but then surely that increases the cost of litigation alongside it. And it's not just the size of data that we have to consider impacting disputes, it's also data types and associated processing platforms, the access rights to the data and the further management of it. As things such as digital twin progress and common data environments are shared between employers and contractors, consideration will have to be given to understanding the technology licensing and associated risks and liabilities. So as you'll see at the bottom of the screen, there's many types of software license, those providing free use for open source development to more restrictive proprietary licenses. Technical licensing can be a very complex area. Not only is understanding the applicable license type important, but keeping up to date with regular changes. So if you think, for example, a few years back, Microsoft changed its processor-based licensing to core licensing. So if you think of having to license an Orange, which was the processor, it changed to having to license each segment within the Orange. So that was the cores. And if you're not aware of licensing laws, then changes like that can have serious repercussions in terms of hefty sums down the line. Virtual licenses can be even more complicated. Just going back to digital twin, and as information models increase the quantity of integrative components, the more complicated the asset management is likely to become from the integration of many components. So consider drone technology, geolocation databases, what are the license restrictions, and more importantly, which party will be responsible for understanding those and the cost of the licenses. Why is software licensing relevant to construction disputes now? On the next slide, we will step through an example. So some of you may be aware of the Trant versus McDonald case, where access to the BIM, or the Building Information Model, was revoked by McDonald. McDonald claimed in response to non-payment there was no contract, and subsequently suspended performance, revoking their copyrights and intellectual property rights in the design data that was being used in the project. Trant sought an injunction to access the model, which was granted, and they successfully contended that withdrawal of it prevented the project from proceeding without incurring significant delay. So this example sets the scene for the scope of potential disputes going forward, as it highlights issues that could likely be exacerbated as modelling information systems become more integrative. Some upfront considerations for future projects are therefore who hosts and controls the common data environment and ensure it's protected against vulnerabilities, backed up and operative. Are the parties aware of their collaboration responsibilities? Are these supported contractually? And who actually owns the design? On the next slide, we'll see the types of disputes already occurring within technical implementations that would likely propagate into E&C projects where technology plays a fundamental part. So as you'll see on screen, there's 3 examples there. These aren't covering all disputes, but these are what we envisage will be the more prominent ones. Firstly, as highlighted by the Trant versus McDonald example, although technology was not the cause of that particular dispute, it did provide leverage. So in this slide, we'll explore common cost-heavy tech-based disputes, which could also occur. Starting with fitness for purpose disputes, these typically centre around the failure or inadequate design of core platforms. So if you think back to the RFID tagging system in Owen's case study, if that got corrupted and lost all the data, and that was grave enough to delay the overall project build, there would likely need to be an investigation into what went wrong. Was the RFID tagging system fit for purpose? Was it designed appropriately? Why did it fail? And what was the impact and who was responsible for the delay? Moving on to licensing disputes, these have the ability to impact projects where many integrated software or hardware components are fundamental to the project and their licenses have not been correctly counted or assigned appropriately. So an example is if you think of an employer and contractor sharing user credentials, to an analytics application that's used in the live project, by sharing credentials, they are potentially breaching access policies and licensing laws where licenses are operating on a strict amount of users. This could therefore likely become a more common dispute cause in tech-enabled E&C disputes, where staff on the ground don't necessarily understand the ramifications of what is seemingly an innocent collaborative effort. And lastly, the intellectual property disputes. So as with the Trant McDonald example, these can stem from copied or inappropriate use of data and or design relating to the technical platforms and applications. IP disputes could halt usage of other real-time project status technology. If we think an example might be where you have wearable tech purchased for on-site, and they are alleged to infringe a popular well-known brand, those infringing items may cease to be supported and usable on the project if third-party litigation outside of the E&C project commences successfully. So that would inevitably cause disruption to the overall build if you have technology that's no longer being supported. So that's outside the liability of the contractor or employer, but still a project impacting issue stemming from technology. In consideration that all the dispute scenarios below revolve around not just data, but associated platforms, hardware, infrastructure, etc., associated dispute costs, say where platforms need to be kept live for expert analysis, can spiral. Internally, we've seen approximately 40% of fitness for purpose disputes settle in the last 2 years, where a key factor was consideration of platform maintenance costs. So I'm now going to just move back onto the topic of AI as introduced by Owen, and thinking about how that could influence future disputes. In expert analysis, we're often tasked with opining on causes of failure. Not only is it important within disputes analysis to see when something happened, but critically knowing why it happened. We ultimately need to be able to see the project decisions made, to be able to look at a point in time and assess the status of the project. So the key question is, how will we be able to do this with project decisions made or informed by AI? How will we capture why a particular decision was made when these decisions are being made automatically by machines? And how will we define if the moment a particular choice was made, it was at the right point in time? If technology and applications are going to be used to inform real-time project decisions, then ultimately that needs to be auditable for retrospective analysis. Thinking of AI-driven project decisions, how do we ascertain liability in relation to a mistake or failure that delays a project or breaches a contract, and how will risks be mitigated? Some of you may have heard of the Davis case from September last year. So Davis was an AI machine, and in that case, the judge ruled that AI cannot have a legal personality and therefore cannot be held liable at law. So in consideration of that and applying it to the construction industry, if, for example, an expensive tunnelling mistake was made by an AI-controlled miscalculation, but that was being fed geological data acquired by the contractor, is the AI provider liable? There are many considerations that will have to be given time and thought down the line. Presently, the UK doesn't have any specific AI laws, and only very recently has the EU published the draft regulations on AI, which thankfully has provisions for activity logging, traceability and detailed documentation for what it considers critical systems, which I believe is certainly a step in the right direction. However, we also need to keep one eye on how digestible this material is going to be, making sure it doesn't become too unmanageable to be useful. AI already needs feeding lots of data to become more accurate, so the additional generation of audit data is only going to add to already big data in terms of processing for dispute. And we also need to consider how that might affect presentation in court. Will it force more technical expert evidence into construction trials, etc.? So in summary, we are already seeing increasing challenges in dispute data collection, having to cater for historic technologies such as backup tape drives and older media, whilst building tools to support advancing technologies such as those used for digital twin. And this is inevitably increasing the complexity of data management platforms, requiring either lawyers to skill up or increasing technicians involved in the dispute from start to finish, or possibly both, likely both. As more E&C technology-based tools come to market, the more potential for project data to reside in disparate systems, therefore, again, requiring more specialists, more bodies, all bringing time and cost implications to collecting, processing and hosting dispute disclosure. Software auditing and compliance will be another key factor in technology-heavy E&C projects, as we spoke of before. Keeping abreast of licensing types, potential AI risks, understanding data ownership, contracting for obligations to monitor data, and understanding the design of project decision-making tools to avoid project conflicts and mitigate dispute leverage will all require focus. And lastly, we think that you can't expect digital data to rise up from the screen and evidence itself, or it could be a futuristic possibility, but at the moment we have to consider the potential increase in the complexity of presentation in courts and arbitrations. So digitalised as planned versus as built demonstrations that rise from the screen may likely be the norm when presenting evidence, which is impactful and brilliant, yet it's costlier to achieve than the old standard flip chart or drawing board. So can courts keep the pace with the cost of these advancements in order to allow parties to present a clearer case at trial? It could be the case that moving forward, the abundance of project data enables a more succinct and clearer case to be presented, essentially reducing required expert or witness evidence, thus reducing trial durations. Or it could go the other way. It could be that they become extended due to the sheer quantity of project material available to present. Time will only tell. I suspect it could be 50-50. And that's the end of this section. So hopefully some thought-provoking considerations, and I will now hand over to Rory.
Great, thank you very much, Siobhan, and good afternoon, ladies and gentlemen. And what I propose to do just over the short time available to speak on some of the legal issues is really condense everything into 2 slides that I have here. But fundamentally, there are a vast array of legal issues that can be considered in relation to the topics that have been addressed by my colleagues at BlackRock. And what I can do is look at some of the key considerations that we see across project lifecycle and some of the challenges that we can see. And they've been well enumerated by Owen, Siobhan and Declan. And you can see and get the sense that there is the potential for the legal system to be overwhelmed by data and processes to be overwhelmed by data. But again, that's something that the legal system is generally well suited to, challenge that the legal systems are well suited to meet. And we see that in tech contract disputes themselves. So really what I wanted to talk about briefly were the 3 zones of activity that we see from a legal perspective. And one is effectively the project setup, the contract execution phase, the negotiation of contracts, the basis on which, and in particular, the basis on which parties engage in collaborative systems, because that is relatively new. It overlayers a lot of contractual relationships and brings with it the potential for very significant liabilities that haven't been foreseen or properly addressed in contracts. Then what I'll look at briefly is the provisions we're seeing, particularly in large-scale tech contracts, data plants, chip plants, and so on, of very high value, where the client is insisting on audit rights down through the contractual chain. And that is an extremely powerful tool that cuts through a lot of the issues arising on construction contracts, and certainly is inimical to the genesis of the global claim. And then finally, I'll just say a few words about the dispute process and discovery and what that means, and picking up on some of Siobhan's comments. And in fact, you can move to the second slide, really, which just reiterates those points. But in many ways, the project setup, the project negotiation, contract negotiation phase is critical to working out how particularly a collaborative system is going to work and what kind of issues it might throw up. And in fact, the Trant versus Mott MacDonald decision that Siobhan mentioned is perhaps a very good example of what is generally going to go wrong if you don't get your contracts in place with the right provisions to deal with the type of data systems that you envisage using in your project. Trant, in many ways, pretty simple. It was the construction of a power plant in the Falkland Islands on behalf of the British Ministry of Defence. Trant won the contract. It took on Mott MacDonald as a designer, but didn't really get to the contract execution phase. Mott MacDonald sent across some terms and conditions to Trant and then started working. One of those terms was that the Trant wouldn't have a copyright license in any of the Mott MacDonald design data until it had been paid everything it's owed. And that is something that you'll typically see in relatively standard design appointments, but one that you won't see in a project of any kind of sophistication because of its implications, and certainly one you won't see in any kind of bank-funded project. But anyway, things didn't obviously go well, and they fell out, and money was claimed and so on. And Trant did get its injunction for the delivery up of the BIM model data. And by the looks of things, it was a level 2 BIM system. The law report doesn't indicate which it was. But so far, so good. They got a mandatory injunction. That's great. And you can almost see the end of season 1 cliffhanger that's going to arise there, because the law report indicates you've got a contentious IP situation. You don't have an IP license in place. Your mandatory injunction is in fact worthless to you. What it does there is gives you the data, but in an unusable format. You cannot take it forward within your project in any kind of way. You don't have a license to use it, or at least you have a contestable right or claim to one, which is probably as good as having no license at all. So you end up with, and you can see the result of this actually in what you might call the return fixture of Mott MacDonald versus Trant, and that decision was handed down by the UK Technology and Construction Court in March of this year. And that is Mott MacDonald making financial claims against Trant. And the decision itself isn't really so interesting in the ins and outs of what was claimed and what have you. The indicia of what then happened after the first case really tells you, I think, all you need to know. The law report alludes to the settlement agreement that was entered into after the injunction was granted. That settlement agreement was effectively Mott MacDonald telling Trant the conditions under which they'd have access to the intellectual property material. And you have a limitation of liability of £500,000 on a €55 million project. You have a net contribution clause, and I'll talk about that in a moment, but it's a key aspect of limiting liability in collaborative systems. But effectively, it's the shopping list of what the consultant wants to protect itself against liability in using a collaborative system. So the second judgment, as I say, it highlights what happened. Trant got the mandatory injunction, but it was pretty much worthless without the IP rights. And what you're looking at really in collaborative systems is the risk allocation and especially around the joint development of design on a collaborative system, particularly say level 3 of BIM. What that means when parties are collaborating to develop design, how is that reduced into contractual format? What's the division of responsibility? If it's not done properly, it's likely to end up, when things go wrong, to be a disaster for at least one of the parties. And particularly if I allude to the Irish context in terms of shared liability, under the Irish Civil Liability Act and the contribution indemnity legislation, you have a joint and several liability for what are called the concurrent wrongdoers. So really anyone sharing in the design development is at risk of taking on that joint and several liability. In the English system, it's a little bit different, but approaching the same outcome in certain circumstances. So there you come to the requirement for the consultant to have a net contribution clause to protect themselves. And effectively, that's the consultant saying, if things do go wrong in a collaborative system, I'm only going to take the share of responsibility that's effectively equitable or just for me to take. So I'm not giving you a joint and several remedy. Very important to work out what is the risk allocation amongst parties collaborating in a design system, and also who holds the ring, who controls the system, what are the IP rights, who gets the IP licenses. All of these things blend into a very complex picture, and without that being settled very clearly, and there are a number of protocols that sit behind many of the standard forms of contract to use at least that level 2 of BIM When you get to level 3 of BIM, things can become particularly complex. But if things aren't addressed properly, there's potentially very significant liability profiles arising. And what you're looking at potentially is a joint insurance policy sitting above the project to de-risk it and allow the design interfaces to work properly. And that's something, obviously, there's not enough time on this session to talk about in any kind of detail. But I just raise that thematically as the type of issues you're going to be looking at and the absolute criticality of getting that right. Secondly, then, I'll just talk a little bit about the data load, as it were. And as you can see from Declan, Siobhan and Owen's talks, that you have a vast amount of real-time data being generated on projects, and that is of very significant evidential value. And it is generally proprietary. However, the contracts, and particularly sophisticated contracts, are looking through that and demanding access to that information and demanding access to it in real time. And it's an extremely powerful tool. And if those clauses are drafted correctly and stepped down through the chain of contracts correctly, then there is a remedy available to obtain information in real time. And the significance of this, for example, from a client's perspective, is if they anticipate or if they are facing very large claims, they're entitled to get straight into the data themselves at the same time as the contractor or the subcontractor who is trying to develop their case theory or trying to work out themselves what the critical impact is between competing causes, potentially some of their own responsibility and others not. So you have a competition for data in real time, and that is an extremely powerful tool, one that's increasingly prevalent, and one that is going to feature significantly. If you look at it from for example, in an arbitration context, and from giving a nod, as it were, to Arbitration Ireland, in the Irish Arbitration Act of 2010, the arbitrator has the power to grant orders of specific performance, and that's something that can attach to real-time audit rights. So really, that's the only point I'll make, really, just to perhaps put some additional context on the data load issues. And you've also obviously got the use of AI in these systems and so on, and it is obviously extremely complex. And what it produces is again, evidentially, it raises a lot of interesting questions. Finally, then, before we move to questions and hand back to Gerard, I'll just say a little bit about the dispute process, the electronic discovery, vast data load, the use of what's called AI. Effectively, it's data, searching for patterns within data. There's some great propensity models that'll give you indication of what's going on in data loads. Given the volume of data, it's becoming impossible, obviously, for individuals to search through them. And AI systems are becoming quite important, or are very important. Great translation facilities in them. And you then have these issues being brought into the discovery process itself from an early stage to try and design the electronic solution. And the final thing I'll say about that, perhaps just really by way of example, the use of discovery requests, many of you be familiar with, the introduction of Boolean logic indicators and request parameters into the discovery requests themselves, and parties trying to indicate to other parties in dispute processes how searches should actually be performed and what search parameters should be used. Now, we've seen that done, we've seen that requested, it's very interesting, but it forms no part of the discovery obligation. So it is something that is being put forward as being a requirement that parties should adopt it and so on. Maybe they will adopt protocols, some do, some don't, but there's certainly no discovery obligation of that nature within your standard common law rules. It's obviously something that can be developed by consensus and so on by parties. And really, look, with that's really all there's time to talk about, but I hope that gives you just a flavor of some of the issues we're looking at as lawyers around in the data environment. And Gerard, I'll hand back to you now as our chair of our session.
Rory, thank you very much indeed. That was truly fascinating, and thank you to all the speakers. It's a whirlwind tour, really, of the the options and the technologies there, and the risks and liabilities that may well arise. It's fascinating, really. I have to say. We have a number of questions in on the Q&A function. Maybe I'll just start with one or two myself to get the ball rolling. I think we have a few minutes. Rory characterizes it quite a bit as collaborative systems, the data sharing aspect. And Owen, I wonder, or Declan, or anybody that wants to answer the question, is there a cultural shift taking place towards the use of collaborative systems, or are there pockets of resistance still existing that really at a client level, employer level, or contractor level that don't want to embrace those collaborative systems? What's your view on that?
I'll fill this first, and maybe you jump in afterwards. So I think COVID obviously has had a big influence on technology over time, over this period, and a lot of people have become more technology aware and adopted a lot of technology tools. I always think back to at the start of COVID when I was working with a major developer in the UK. They were very much traditional type of office setup, and when it hit, one of my roles was helping them coordinate getting laptops and VPN accesses out remotely. So like there was a lot of organizations who really didn't even have that level of technology toolkits in place. But I think in terms of the culture, I think it's a really important point. And the one thing I would emphasize is around the structure and the quality of information you're capturing and having a point to it. One of the key issues that we came across in that example I touched upon was in the how information was shared across that project and how difficult it was to reconcile the information across. And I think that the overall cultural piece I would try to adapt initially would be setting those rules, setting guidelines as to how information should be managed, how should be maintained, and how we can use it and grow the insights from that data as an asset going forward. I'm not sure, Declan, if you have anything else to add on top of that.
I guess just for me, the cultural one is always a really tough one, and it does come back to that quite a lot actually. And in my opinion, it's probably driven in a large part by low margins and recovery from contractors, pretty much, which does drive a set of behaviours which is less than ideal. And I think there's an external stimulus required, not in a financial sense, but an external stimulus in terms of a shift or encouragement in terms of changing that behaviour. And you can start to see that in some respects through larger scale public projects where they require or mandate certain things like partnering arrangements, sharing of data in environments, etc. So you can start to see the green shoots there, but when it comes to it does seem to be the laggard that seems to come behind absolutely everything. And I'm not sure if there's going to be a point later on the contracting arrangements behind it, but that's even more complex than to try and drive it back up the chain in terms of how you should behave and interact whilst the thing is not in dispute.
Yeah. Thank you very much. Rory, a question for you perhaps. We've spoken a lot about the reliability of data and the auditing systems, etc., that need to be there to give you confidence in the data you're seeing. In the context of disputes then, and how a disgruntled party might challenge data. I mean, obviously if the data has been presented by one party only, you can challenge the collation of the data, the auditing records and all the rest. As councillor, if you were a party representative, do you think there's scope at all for challenging collaborative data collected, or is that kind of a closed shop? You have nowhere to go with that?
Well, it's a very interesting question, Jared, and you start really from the premise of the what's being proved by the data, what's being put forward in order to achieve, and what are the issues in contention in the case. And obviously, certain type of data is going to be very probative regarding the issues in dispute, and we see it many times particularly in construction disputes, prolongation claims, and so on. The use of photographic records and so on. That's data, that's proving, that's showing you what's going on and so on. When you get into more granular and very specific data, then obviously there are issues potentially around it in terms of what's been proved, what has been put forward to prove, and there is always room for a further consideration and contradictory evidence and so on.
But if it's coming from a collaborative system, Rory, where they're in effect sharing the data throughout the currency of the project itself, does that limit the scope, perhaps? somewhat for challenge or for proving, as in it's there?
Yeah, no, look, in terms of its raw form, absolutely, it's going to be a contemporaneous record of the project. So it's not necessarily going to be open to challenge for that purpose. What it actually means, though, is potentially another issue for exploration.
Of course. Okay, thank you for that, Rory. Can the speakers see the questions that are in the Q&A box, or do I need to call them out? You can see them, can you?
Yeah, we can see them. Yeah.
There's one there from Tim Witcher on monitoring effectively of inclement weather entitlement, and you know, if there are smart contracts provided automated early warning notices if certain weather parameters were triggered, would that automatically generate an award or entitlement? Anybody want to take that question? What's the view on it?
Well, interesting enough, so the project I referenced on the high-rise development had weather monitoring sensors over the height of the project. So because it was so high, and the wind and the turbulence affected by that by the buildings around it would change depending on the height of the lift of it. So they were using monitoring sensors to kind of determine the use of when it was applicable to make a certain lift and to prioritize movements of material around site. I think in theory, I think it would work from an early warning notice system. There's obviously a lot of issues that are around that in terms of if you're using it to for example, if you're using it to predict in the future like what the weather patterns are going to be. I'm not sure how that would play. I'm not sure, Rory, if you have any kind of insights on that from what you've seen in contracts and how people have used that kind of prediction methodology.
Yeah, I mean, look, it'll also, I mean, it's effectively potentially a form of evidence, but it comes back to your primary question. If you got, is there weather related delay in the first place? Is it causative? Is it critical? All of these type of things. So it's, you know, that's you can see its role. Does it fundamentally change things? Potentially not.
Okay, thank you for that. Another question in there from Alan Moore, and I think, Rory, again, you touched on this in your presentation. It's really, have any of the standard form construction contracts, NEC, JCT, FIDIC, etc., started to consider these new emerging issues in their new forms? I mean, I think FIDIC, and Rory, you may have mentioned it, in the more recent forms certainly have, you know, requirement for contemporaneous data and contemporaneous records at clause 20. Do you want to comment on that?
Yeah, no, absolutely. That's substantiation's always been obviously a strong feature of FIDIC and all of the related kind of British-derived contract forms. What you're seeing obviously also is over the last 10 years, BIM protocols, which are really critical if you are using a collaborative system. It's essential that you have something like that. NEC3 has a very good protocol, and there's an increasing array of them. So yes, in short, yes, there are. There's developing drafting around all of those systems.
Very good. Just doubling back maybe to the, I know we're over the hour now, maybe doubling back to the arbitration Ireland and the arbitration focus in and of itself. Do any of the speakers or see an issue, maybe Rory, possibly back to you again, you know, for arbitrators sitting in construction disputes? You know, traditionally we know our adjudicators, we you know, hear the stories about 10 lever arch files of data been wheeled in from different parties, and you know, the arbitrator or adjudicator is obliged to consider everything that's put in front of himself or herself. With tracking facilities now with IT software and otherwise, is there a risk for an arbitrator that a party could say, if they wanted to resist if it's an enforcement challenge or otherwise, that arbitrator A or arbitrator B didn't actually access my files? I can see that he didn't access the digital files that I sent him, and where might that sit?
I suppose a couple of overlapping issues there, Jared, and it's obviously not beyond the realms of possibility that people bring challenges against arbitrators on those type of grounds. Fundamentally, it is up to the parties to prove their case in the dispute process, as it really is that the primary feature of arbitration, and it's up to the parties to present the evidence. Whether that extends to the arbitrator having to carry out their own investigations into masses of data to try and verify issues, that's another matter. But the use of data within arbitrations and really in any highly evolved process, the rules by which that data is presented, used, formulated, and so on do become quite important, and the system being deployed. But obviously, for example, if the data not being accessed is a submission by one of the parties submitted electronically, you might find there's trouble. But in principle, as I say, the parties present their case, and obviously it must be considered. Challenges have been brought on the basis of an arbitrator allegedly not having reviewed material presented in the traditional hard copy. Those challenges generally haven't succeeded. To my knowledge, perhaps there are examples where obviously it has, but it's difficult if there's no injustice demonstrated.
Thank you very much, Rory. Look, I think we'll take one more question, then we'll wrap it up. There's a question there on the Q&A function from Anthony Morgan. You can read it yourself. I think for the panel, how did they foresee the issues with pricing and management of risk with the transparency of costs and time performance that a collaborative system gives the parties? Does anybody want to take that question? Any takers?
I suppose, Jared, I could make a brief comment on it. That is, and really it's just an observation. I'm perhaps not the best person to be talking about, say, time and cost analysis, but in high value cost plus contracts, that's really where you're seeing the audit rights exercised and imposed so that people can look through into real-time financial data.
Very good. All right. Any comment from Declan? You were going to say something there?
No, I was just thinking how you could unpack it, because it's actually a massive area in terms of the transparency, especially around risk and provision of risk in contracts in terms of an EMV. But I think it's such a big one. I'm not quite sure how you'd take it. So from experience, sometimes EMVs can be calculated simply as a percentage of a lump sum figure that is held and divvied up in terms of responsibility between the parties. So you can have management, reserve, contingency, and then identified risk, and the relationship of those things changes over time. And therefore you could systemize that in a certain way. There's a lot to unpack in that. I know, Anthony, I might have a follow-up on afterwards.
All right. Look, thank you for that. Look, we're an hour and 10 minutes in. I think I might call it a day, if that's okay with the speakers and the panelists. It's been a truly fascinating hour and 10 minutes. I want to thank you all sincerely for the quality and the content of your presentations. It really was something for us all to take away and learn from. This issue is not going to stop dead in its tracks. It's going to continue. It's multifaceted. I think we'll be back here again before long discussing the topic further. So to Declan, Siobhan, Rory and Owen, on behalf of Arbitration Ireland and on behalf of BlackRock Expert Services, on behalf of all the attendees, I want to thank you most sincerely once again. And to all the attendees, I hope you got something from it. The recording will be provided shortly, I understand, I think within an hour or two of the presentation, and will also be available on the Arbitration Ireland website. So with that then, I'll bid you all a good evening, and thank you again for that. Take care.
Thank you.
Thank you, Jared.
Bye-bye.
Thanks, everyone.
Slán.